So hello everyone and welcome back once again. In today's video we will just discuss the previous year question paper of AIBE 14 that was held in 15th September 2019. In this we will see total 100 question. We will try to always solve 100 question. Basically I am analyzing, and with me if you will analyze it, so it gonna beneficial for both. Question number first says, which one of the following sentence is correctly method? Option A we have, which one of the following sentence is correctly method? Option A, in India consideration must follow from promisee only. Option B, in India consideration must follow from only promiser or only promisee. Option C, in India consideration must follow from promiser or any other person. Option D, in India consideration must follow from promisee or any other person. Its right option is option D, that is, in India consideration must follow from promisee or any other person. Question number 2, assertion A, collateral transactions to wagering are valid. Collateral transactions to wagering are valid. Reason: only wagering agreements are declared void under Section 30 of Indian Contract Act. The options we have: A is true but R is false. A is false but R is true. Both A and R are true, but R is not correct explanation of A. Both A and R are true, but and R is correct explanation of A. Its right option is option D, that is, both A and R are true, means collateral transaction to wagering are valid. It is true, as well as its valid explanation is only wagering agreements are declared void under Section 30 of the Indian Contract Act. Next question, question number 3. The term holder include a payee, a bearer, the endorsed, the payee, the bearer, the endorsed, or all of the above. Its right option is option D, that is, all of the above. Means the term holder includes a payee, a bearer, as well as the endorsed. Question number 4. Under the dissolution of marriage, under the Dissolution of Muslim Marriage Act 1939, a Muslim wife can seek dissolution of marriage if the husband fails to perform marital obligation for option A 2 years, 3 years, 4 year, 5 year. Its right option is option B, that is 3 year. Question number 5. The concept of curative petition was introduced by the Supreme Court of India in the case of option A Rupa Sokhura versus Sokhura EIR 2002, MC option B MC Mehta versus Union of India AIR 1987, option C Krishna Swamy versus Union of India 1992, option D Sheila Barse versus Union of India 1986. Its right option is of question number 5 is A, that is Rupa Sokhura versus Asokhura. In this, the concept of curative petition was introduced by Supreme Court. Question number 6. Right to fair legal aid was recognized. Right to fair legal aid. I guess it is free. Fair, not fair, free. Legal aid was recognized as a fundamental right under Article under Article 21 of Indian Constitution. In the case of options, we have Hussain Ara Khatun versus State of Bihar, EIR 1979 Supreme Court. Option B, MH Hoskote versus State of Maharashtra, AIR 1978. Option C, Madhu Mehta versus Union of India, 1989. Option D, Radul Shah versus State of Bihar, 1983. Its right option is option A, option B, option B, that is MH Hoskote versus State of Maharashtra. Let me just confirm. Is it a fair legal aid? I was thinking Hussein Ara Khatun, but it is related with speedy trial. Speedy trial uh, under Article 21 of Indian Constitution, and MH Hoscott case. Yeah, MH Hoscott case is basically talks about the free legal aid. Okay, so its right option is B only. Question number 7. The case of Muhammad Allahdad Khan versus Allahdad Khan versus Muhammad Ismail Khan is related to preemption. Option B, gift. Option C, meher. Option D, acknowledgement of paternity. Its right option is option D, that is acknowledgement of paternity. Why the line is not doing as a state? You can adjust the video accordingly. So if I am going like slow, so you can uh, give the speed, uh, give the speed to this video, like you can watch it on 2x or 1.75x or 1.5x according to your comfortness. So see accordingly. Okay. Question number 8. In which of the following cases the Supreme Court was in 2017 declared pronouncements of talaq three times at a time by Muslim husband as unconstitutional? Option A, Sayara Bano versus Union of India. Option B, Sasneem Ara versus State of UP. Option C, Bed Tahira versus Ali Hassan. Option D, Daniel Latifi versus Union of India. Its right option is option A, that is Sayara Bano versus Union of India. Talks about the three times of saying the three times uh, talaq, pronouncement of talaq at three times by a Muslim husband is unconstitutional. Held in Sayara Banu versus Union of India. Question 9. Mesne profits of property means option A, those profits by which those profits by which the person in wrongful possession of such property actually received or might have received there from together with interest on such profits. Option B, the profits due to improvements made by person in wrongful possession. Option B, the profits due to improvements made by person in wrongful possession. Option C, both A and B. Option D, none of the above. Its right option is option A, that is those profit by which the person in wrongful possession of such property actually received or might have received there from together with interest on such profits. Question number 10. Which of the following is not a legal representative? Which of the following is not a legal representative? Option we have executor and administrators. Option B, Hindu co-partners. Option C, creditors. Option D, intermeddlers. Right option is option C, that is creditor. Question number 11. Public interest litigation is relaxation of which of the following requirements? Option A, jurisdiction. Option B, locus standi. Option C, both A and B. Option D, none of the above. Right option is option B, that is locus standi. Question number 12. Which of the following is not a case of public interest litigation? Option A, Keswanand Bharti versus State of Kerala, AIR 1973. Option B, Vinket Narayan versus Union of India, AIR 1988, Supreme Court 889. Option C, Union of India versus the State of Democratic Reforms, AIR 2002. Option D, Vinket Panikurlangara Panikurlangara versus Union of India, AIR 1987. Right option is option A, that is Keswanand Bharti versus the State of Kerala. It is not related with public interest litigation. Question number 13. Which of the following can be done by a which of the following can be done by a by a senior advocate in accordance with the rules of Bar Council of India? In accordance with the rules of Bar Council of India. Option B, make concessions on behalf of client on instructions from junior advocate. Option B, accept instructions to draft a pleading. Option C, accept brief directly from client. Option D, none of the above. And its right option is option A, make concessions on behalf of client on instructions from junior advocate. Question number 14. Which one of the following is true about the maxim ubi jus ibi remedium? Option A, where there is a right, there is a remedy. Option B, where there is a remedy, there is a right. Option C, both A and B. Option D, none of the above. Right option is option A, that where there is a right, there is a remedy. Question number 15. The Latin word injuria sine damnum literally means injuria sine damnum means options we have. Option A, infringement of legal right without damages. Option B, damages without infringement of legal right. Option A, both A and B. Option D, all of the above. Right option is option A, infringement of legal right without damages. And what was the quote? That was injuria sine damnum. Injuria sine damnum means infringement of legal right without damages. Question number 16. The provision relating to claims tribunal is given under dash of Motor Vehicle Act. Option A. Provision relating to claims tribunal is given under dash of Motor Vehicle Act. Under options we have under section 165 to 175, 175 to 180, 170 to 175, and 171 to 177. The right option is option A, that is section from section 165 to 175. Question number 70. Rule of law means option A, equality before law. Option B, supremacy of the law. Option C, predominance of legal spirit. Option D, all of the above. The right option is option D, that is all of the above. Question number 17. Rule of law means equality before law, supremacy of the law, predominance of legal spirit. Question number 18. The purpose of writ of quo warranto is option A, to compel public authority to perform duty. Option B, to restrain public authority to do illegal act. Option C, to oust illegal occupant of public post. Option D, all of the above. to oust illegal occupant of public post. Its right option is option C, to oust illegal occupant of public post. Its right option is option C. Question number 19. The writ of certiorari can be issued. The writ of certiorari can be issued against option A, judicial and quasi-judicial bodies. Option B, quasi-judicial and administrative bodies. Option C, administrative bodies only. Option D, none of the above. The right option is option A, means against judicial and quasi-judicial bodies. Question number 20. Supreme Court of India held that it is permanent obligation of every member of medical profession, either government or private, to give medical aid to every injured person brought for treatment immediately without waiting for procedural formalities in the case of option A, Common Cause versus Union of India 1996. Option B, People's Union of India AIR 1983. Option C, Parmanand Katara or Katara versus Union of India EIR 1989. Option D, Lakshmikant Pandey versus Union of India 1984. Its right option is option C, that is Parmanand Katara versus Union of India EIR 1989. Question number 21. The Supreme Court of India has issued the direction to make the CBI independent agency so that it can function more effectively and investigate crimes and corruptions at high place in public at high places in public life. In the case of options, we have option A, Union of India versus Association for Democratic Reform AIR 2002. Option B, Bangalore Medical Trust versus BS Mudappa 1991. Option C, Vinket Panikur Panikur Langra Venkat Panikur Langra versus Union of India 1987. Option D, Venkat Narayan versus Union of India AIR 1998. Mm-hmm. Its right option is option D, that is Venkat Narayan versus Union of India AIR 1998. Related with CBI independency. Question number 22. One of the following statements is not true. Which one is that? Option A, a confession by one co-accused implicating other co-accused would be proved. Option B, a confession to a police officer cannot be proved. Option D, a confession by a person in the custody of police officer to any person in the presence of magistrate can be proved. Option D, if the confession of a person leads to reco- recovery of a thing, it can be proved. Its right answer is option A. Option A. A confession cannot. A confession by one co-accused implicating other co-accused would be proved. This statement is not true. कि मतलब एक को-accused ने दूसरे एक को-accused दूसरे accused के behalf पे confess नहीं कर सकता है और इसमें लिखा है कि वो प्रूफ कर सकता है, हो सकता है. Question number 23. The Kashmira Singh versus State of MP is a leading case on option A, dying declaration, option B, admission, option C, confession to police officer, option D, confession of a co-accused. Its right option is option D, that is confession of a co-accused. Kashmir Singh versus State of MP, leading case on confession of a co-accused. Question number 24. Which of the following fact is not relevant in civil and criminal cases? Under Section 8 of Indian Evidence Act. Option A, motive, attempt, conduct, preparation. Right option is option B, that is attempt. Question number 25. The BATNA stands for, that is Batna or Batna, stands for option A, bilateral agreement to negotiation and arbitration. Option B, best alternative to a negotiated agreement. Option C, bilateral trade negotiated agreement. Option D, none of the above. Its right option is option B, that is best alternative to a negotiated agreement. Question number 26. Section 9 of the Arbitration and Conciliation Act 1996 deals with option A, interim measures by the court. Option D, discretionary power of the court. Option C, both A and B. Option D, none of the above. Its right option is option A, that is interim measures by the court. So Section 9 of the Arbitration and Conciliation Act 1996 deals with interim measures by the court. Question number 27. For the first time in India, income tax was introduced by the Sir James Wilson in the year. Options we have 1886, option B 1868, option C 1860, option D none of the above. The right option is option C, that is in 1860. In 1860. So by Sir James Wilson, the Indian income tax was introduced in 1860. Question number 28. In which case Justice J.C. Shah of Supreme Court observed, since by the exercise of the power a serious invasion is made upon the rights, privacy and freedom of the taxpayer, the power must be exercised strictly in accordance with law and only for the purpose for which law authorizes it to be exercised. Options we have Director of Inspection versus Puranmal. Option B, ITO versus Seth Brothers. Option C, PR Metrani versus CIT. Option D, none of the above. Its right option is option B, that is ITO versus State Brothers. Question number 29. Which of the following statements are true? Option A, minors contract can be ratified on attaining majority. Minors contract can be ratified on attaining majority. Option second, minors contract be ratified on attaining majority. यहाँ पर है can, minors contract can be ratified on attaining majority. Minors contract contact, this is what contact, minors contract be ratified on attaining majority. Option C, minors contract can be ratified jointly by both the parties to the contract. Option 4, minor is not liable under minors contract. True बताना है. And its right option is option second, that is minors contract be ratified on attaining majority. Oh, sorry. So these were not option. These were not the options. ऑप्शन ये है. ऑप्शन ए फर्स्ट एंड थर्ड. ऑप्शन बी सेकंड एंड फोर्थ. कौन सा स्टेटमेंट सही है? ऑप्शन सी फर्स्ट एंड सेकंड. ऑप्शन डी सेकंड एंड थर्ड. इट्स राइट आंसर इज ऑप्शन बी सेकंड एंड फोर्थ. Means minors contract be ratified on attaining majority, as well as minor is not liable under minors contract. Option B. Question number 30. Which one of the following sections of CRPC deals with irregularities which vitiate proceeding? Question number 30. Which one of the following sections of CRPC deals with irregularities which vitiate proceeding? Option A, section 460, option B, section 461, option C, section 462, option D, section 468. Its right option is option B, that is section 461. So section 461 of CRPC deals with irregularities which vitiate proceedings. Question number 31. Which of the following is not an essential element of a decree? Options we have: conclusive determination of the rights of the parties. Option B, formal expression of adjudication. Option C, an adjudication from which an appeal lies as an appeal from an order. Option D, the adjudication must have been given in a suit before the court. The right option is option C, that is an adjudication from which an appeal lies as an appeal from an order. Question number 32. Which of the following is not a duty of an advocate to court? Which of the following is not a duty of an advocate to court? Options we have: option A, to not commit breach of section 126 of Indian Evidence Act. Option B, to not to appear on behalf of any organization of whose executive committee he is a member. Option C, to not appear before a court, tribunal, or authority in which his near relation is a member. His near relation is a member. To not appear before a court, tribunal, or authority in which his near relation is a member. Option D, to conduct himself with dignity and self-respect during presentation of a case before a court and otherwise acting before a court. Its right option is option A, that is to not commit breach of section 126 of Indian Evidence Act. What section 126 says? Section 126 of Indian Evidence Act of 1872 protects confidential communications between a client and their legal professional. So, not to disclose and prohibit disclosing communication made by a client. But क्वेश्चन पूछ रहा है विच ऑफ द फॉलोइंग इज नॉट अ ड्यूटी, इनमें से कौन सी ड्यूटी नहीं है ऑफ एन एडवोकेट टू कोर्ट. हाँ अच्छा, रिगार्डिंग द कोर्ट. अच्छा ओके. हम्म कोर्ट से कोर्ट से रिलेटेड तो ये रिलेटेड है क्लाइंट से. यहाँ पे पूछ रहा है रिगार्डिंग कोर्ट. क्वेश्चन नंबर 33. विच ऑफ द फॉलोइंग रूल्स ऑफ चैप्टर सेकंड ऑफ पार्ट 4 ऑफ द बार council rules deals with the duty of an advocate in respect of any monies received by him from client? Rule 25, Rule 33, Rule 24. Option D, none of the above. Its right option is option A, that is Rule 25. Question number 35. Under which of the following sections of CRPC provisions relating to police report is given? Options we have section 173, subsection 2, subsection 1 or clause 1. Option B, section 177. Option C, section 174, subsection 2, subsection 1 or clause 1. Option D, that is section 175. Its right option is option A, that is section 173, subsection 2, clause 1. So this is the section related, which is related with the police report, or a police report, to give that report, to submit that report. Question number 35. Which one of the following provisions of CRPC deals with anticipatory bail? Option A, Section 1, Section 437. Option B, Section 438. Section 439. Option D, none of the above. The right option is option B, that is Section 438. Section 438 of CRPC deals with the provision of anticipatory bail. 438. Question number 36. The provision relating to cancellation of bond and bail bond is given under option A, Section 446A, Section 446, Section 447, Section 450. Its right option is option A, that is Section 446A. Question number 37. The provisions relating to Dory is given under option A, Section 304B of IPC, 304A of IPC, 304 of IPC, Section 305B of IPC. Right option is option A, that is Section 304 of IPC. Question number 38. Which of the following section is designed to curb infanticide? To curb infanticide. Options we have Section 317 of IPC, 313 of IPC, 318 of IPC, or 315 of IPC. The right option is option D, that is Section 315 of the IPC. Question number 39. Which order has been especially enacted to protect the interest of minors and unsound mind? Option A, Order 31. Option B, Order 32. Option C, Order 33. Option D, Order 34. The right option is option B, that is Order 34. Related with unsound mind and children or minor. The order, right option is option B, that is Order 32. Question number 40. Which order of CPC lays down general rules governing pleadings in a court? Option we have option A, Order 6, option 7, option Order 6, Order 7, Order 8, Order 9. The right option is option A, that is Order 6. So Order 6 of the CPC lays down general rules governing pleadings in a court. Uh, let's finish it up the video here, and we will continue the video in our part 2. So basically this is going to be part 1, and in part 2 I am going to continue the further questions. So till then, thank you to all of you.